Hi everyone, I'm immigration attorney Andres Mejer. Welcome to today's video of the week. There's been some very interesting news on immigration during the past few days, so I just decided to cover some of them in this video with you. Our first topic, we're going to talk about a Supreme Court ruling that could impact thousands of immigrants currently in immigration detention. And secondly, we're going to talk about good news for refugees. After some weeks with readmission procedures frozen by the Afghanistan situation, refugee resettlement will now begin again. I do these videos to give you the information you need to deal with the immigration system. Information I wish I had when my family was in the same scenario. Knowledge is the best weapon for dealing with the immigration system, and I say it because my family went through all of this, trusting in the wrong people, not knowing any better. As a result, we lost a lot of time and money and achieved nothing. And when I finally got my green card, I almost lost it because I didn't know I could. My father and sister weren't so fortunate, and they did lose their green cards. I don't want that to happen to you. I want to help you, and I want you to have the smoothest and most boring immigration journey of all. Here's to your boring journey. For our first topic of the day, I'm going to talk about a Supreme Court decision that could impact thousands of immigrants who are detained in this country today. On January 11th, a hearing took place involving two cases arguing that immigrants held in detention for longer than 6 months are entitled to a bond hearing in which a judge will determine whether they should be continued to be detained or not. The function of a bond hearing is where an immigration judge decides, is this individual a danger to the community? And secondly, are they likely to appear if they are released? The main argument in these cases is that it's nearly impossible to think of treating a US citizen in that way. Imagine being held without bail for 6 months or forever just because you're a non-citizen. And for that reason and that reason alone. It's crazy. On the other hand, Biden administration seems to disagree with this. Justice Department argues the immigration statute does not give immigrants a hearing and that the lower courts do not have the authority to do so either. How the Supreme Court rules on this issue will affect thousands of immigrants every single year. We've been able to get many of our clients released from detention, arguing that it is cruel and unusual punishment to keep someone detained for more than 6 months or forever. Let's hope the Supreme Court doesn't take that ability away from us. At the center of a lawsuit is a 1996 immigration statute passed under Bill Clinton that says an unauthorized immigrant may remain in detention for an extended period if they fail to meet certain criteria. Based on this, several detained immigrants, including Esteban Gonzalez, one of two individuals involved in these cases, argued that because the statute says may be detained rather than shall be detained, it indicates that a judge has discretion and it entitles Gonzalez and others to be heard, to have a hearing. And what the Biden administration is doing is taking the same position as the Trump administration before them. They argue that the law grants the Attorney General the power to detain unauthorized immigrants for any period while their case is being litigated. Michael Kaufman, who represents Mr. Gonzalez, mentions that the fundamental question of the case comes down to whether the federal government can confine you, can incarcerate you for months or even years without providing the most basic of due process protections. The issue of detained immigrants has been a difficult one for a long time. Several immigrant advocates have called the US government to seek alternatives to detention and have criticized the conditions that people live in while being detained. Detainees are kept away from their families, friends, and work, and now, due to the current pandemic, they have an even greater risk of contracting COVID-19 in detention facilities. If that isn't enough, by being detained, immigrants are limited in their ability to find evidence to support their claims and in finding an attorney to help them, especially when they are moved to another state. We have clients who are detained in New Mexico, in Ohio, in Pennsylvania, in California, in Florida, in Georgia, in Louisiana. when they all lived in New Jersey. And now all of a sudden they're somewhere else, and it's not right. All of this puts the entire immigration process integrity in doubt, aside from human rights issues that arise from forcing someone to remain detained indefinitely, particularly when they have not committed a crime and are not really a danger to society. The number of people in detention has ranged from 20,000 to more than 27,000 in the past few months. The length of time a person spends in detention varies widely, depending on individual circumstances, but it is not uncommon for people to spend months or even years in ICE facilities. We have a client now been detained for 3 months, committed no crime, just because of the vagary of the immigration system, hasn't yet had a bond hearing. That's ridiculous. Whereas somebody that committed a serious crime like sex abuse, sex assault, or murder, or attempted murder, you can understand that's a dangerous person that you may not want to be outside of detention. But someone that's committed no crime, that's done nothing wrong other than being in this country without permission, that's not right. Immigrants going through the immigration proceedings, they're not entitled to a government-paid lawyer. They are entitled to an attorney, but they have to they have to pay for it on their own. Now, those without a lawyer find it more difficult to request a bond hearing. In fact, those without a lawyer are 10 times less likely to succeed in their case. So having an attorney 10 times more likely to succeed than to not have one. Most of those who are in detention are either asylum seekers or undocumented people who have lived in the US for a long time before being placed into detention by ICE. In his original lawsuit, Gonzalez asked the court to extend its ruling to other immigrants who've been detained for prolonged periods of time, otherwise known as granting class-wide relief. A district court and the Ninth Circuit Court agreed. Gonzalez was released after more than 8 months in detention when the court ruled in his favor in April of 2020. Now the Department of Justice is arguing that those courts lacked the authority to grant this relief to anyone other than Mr. Gonzalez. In simple words, the Department of Justice argues that the law says an individual alien and not aliens plural, meaning that a lower federal court does not have the authority to allow a whole group of people this relief. In other words, you have to file for each individual person individually. Classifying this case as a class action is a big deal because class action lawsuits are often how immigrant advocates can help groups of people who do not have access to an attorney. Today, the Supreme Court has a conservative majority of 6 conservative judges to 3 more quote-unquote liberal judges. We hope they're going to address the issue on the merits rather than just on politics. Giving immigrants a hearing doesn't mean an immigration judge will automatically let them out of detention. It only gives them the right to be heard, which is what due process provides. Notice and an opportunity to be heard. We can only hope the Supreme Court makes the right decision. We're just going to have to wait and see. Our second topic of the day concerns refugee admissions. After a temporary pause of refugee admissions implemented late last year, mostly due to the resettlement of Afghan evacuees, the readmissions will restart the week of January 10th, meaning it already started. With tens of thousands of Afghan refugees looking to come to the US, the Biden administration had to put on hold the admission of refugees until they met certain expectations. As you can imagine, this saturated not only the government agencies, but resettlement agencies and organizations all over the country. Now that the situation has improved, this freezing will come to an end and admissions will get back on track. This means that refugees from around the world, not just Afghanis who have undergone processing and checks, will be allowed to enter the US. Sadly, it doesn't mean that they will speed up the process to try and catch up, but hey, at least they're moving forward. The immigration system is slow, generally speaking. Then you add a backlog caused by that pandemic when there were mandatory government closures and people were on lockdown. And you add on top of that resettlement of Afghans that was not expected or anticipated, meaning there was no planning for that. Just overnight, you had to accommodate tens of thousands of refugees. That took an already overwhelmed system by surprise, and it was a recipe for chaos. The freeze was intended to help agencies focus on Afghanis who had been evacuated and already arrived in the US. In many cases, refugee resettlement agencies that partner with the federal government had limited capacity after years of declining refugee admissions under the Trump administration, resulting in closed offices and laid off staff. Since the Afghan situation arose, almost 55,000 Afghanis have been resettled nationwide, and around another 20,500 people remain in military bases as of January 6th, like Fort Dix, where I volunteered to help Afghanis. Now, after refugee organizations and advocates have reinforced their capacity to accommodate evacuees and help integrate them into communities in the United States, they've had time to launch new resettlement offices, hire staff, and build new and stronger relationships with communities and volunteers. They are moving to keep resettling Afghan families off of U.S. military facilities and can now resume their work of welcoming refugees from other countries arriving from abroad. As of November 30th, more than 2,000 refugees have been resettled in the United States in this new fiscal year, according to the latest figures from the State Department's Refugee Processing Center. The fiscal year 2022 cap, which dictates how many refugees can be settled in the U.S., is 125,000. So restarting the refugee resettlement is an accomplishment. Let's hope it's done fast enough that they can process all or nearly all 125,000 visas and not lose visas like they have for the past 2 fiscal years. And I say fiscal year because it's not the same as the calendar year. Fiscal year ends September 30th of, for example, 2022, and October 1st of 2022 will start the new fiscal year. And now we've arrived to the end of our video. I hope you like this video and you find this one, the rest of my videos, useful. If there's a particular topic you'd like me to talk about or to explain, leave a comment below and we'll get back to you, hopefully with a video on the subject. If you want to talk about your case and explore your options, give us a call. Remember, if we can't help you, we're not going to charge you. Don't forget to subscribe, and if you know someone who can use this information, please share it with them. As always, stay healthy and be well.